Good afternoon, everyone, and thank you for joining NAM for today's program, The Importance of Legal Ethics in the Mediation Process, presented by the Honorable Alan D. Scheinkman. Please note that this program is being recorded. Judge Scheinkman joined NAM as a neutral following his retirement as the presiding justice of the Appellate Court, Second Department, New York State Supreme Court, where he was the chief judge of one of the largest and busiest appellate courts in the country. He also serves as a trial judge in New York's Commercial Division. As a NAM neutral, Judge Scheinkman has arbitrated and mediated many cases, including matters relating to construction, trust and estates, sexual abuse, and the Child Victims Act. And with that, I will turn it over to Judge Scheinkman.
Thank you very much, Sharon, and I thank everyone on the webinar who have joined with us today. Next slide, Sharon. Sharon, okay, there we go. Ethics and the mediation process is an important topic. The rules of professional conduct that govern discipline of attorneys have provisions which address various aspects of attorney behavior, but they don't really get into any detail as to how counsel should be conducting themselves during settlement negotiations. The ABA section on litigation has promulgated guidelines which are based on the model rules and based on the ABA ethics opinions to fill the gap. Next slide. The section of litigation, one back, Sharon. I'm sorry, slide 4 before that. There we go. The guidelines for settlement negotiations are not disciplinary rules, so they cannot be the basis of discipline in and of themselves. What they are intended to be is a practical, user-friendly guide for attorneys who need advice on ethical issues that come up during the course of settlement negotiations. I should also mention that the ABA has adopted model codes of conduct for mediators, which are designed to guide the conduct of mediators, inform the mediation process, and promote confidence in mediation. And as a side note, while many mediators are lawyers or retired judges, mediators need not be attorneys and need not be retired judges. So the model standards exist to govern mediators, whether they happen to be attorneys or not. Next slide. The purpose of mediation is to provide the assistance of a neutral third person to help the parties negotiate a settlement. It can be used, and it should be used, to obtain the resolution of a one-time dispute, such as the settlement of a personal injury case, the resolution of a contract dispute, as well as for the purpose of salvaging a continuing business relationship. As we speak today, I've been working on a mediation that involves an ongoing business relationship. Mediation saves time, expense, and risk associated with litigation. It also saves the publicity and embarrassment, which sometimes are unwanted byproducts of litigation. Next slide. The model rules of professional conduct, which are the disciplinary rules, have a standard, Rule 3.2, which is a bold-faced standard. It says lawyers, as advocates, are to make reasonable efforts to expedite litigation consistent with the interests of the client. Mediation advances that goal of expediting litigation by seeking a negotiated resolution. Next slide. The purpose of settlement negotiations is to arrive at agreements that are satisfactory to the client and are consistent with relevant law and rules of professional responsibility. As in mediation, as with everything else, a lawyer is obligated to act with competence, that's under Model Code Section 1.1, act with reasonable diligence in representing the client. Clients are generally not obligated to settle, although there are agreements that may be part of contracts that require that mediation take place before a suit can be followed. And those types of contracts are generally enforced by courts, with the court either staying the court action or dismissing it pending compliance with a mandatory mediation provision. The courts themselves may compel the conduct of mandatory settlement conferences. And both federal courts and state courts have issued rulings that have imposed sanctions on lawyers for failing to appear to attend these conferences. While no court has ever sanctioned a lawyer or a party for refusing to settle, even if that refusal is in bad faith, sanctions have been imposed for refusing to come to the meeting at all. Next paragraph, next slide. So, absent a court directive or a pre-suit agreement, the decision as to whether or not to pursue a settlement belongs to the client. The client has every right to say, I don't want to participate in the settlement conference. The client loses that, as I said before, where there is a contractual provision that requires a pre-suit mediation, or where there is a court-annexed program that says that you must attend a mediation session. Where neither of those requirements is at play, it's generally the better idea to get the client's consent before entering into negotiations. Now, it's not uncommon for lawyers to talk in a hallway and say, wouldn't it be great if we could settle this case? What do you think about this? What do you think about that? But really, those conversations should only follow with substance when the client has been informed and the client has gotten consent. Where there is a requirement that the client participate in a mandatory settlement conference, whether because of contract or by course of court rule, the lawyer should explain to the client the significance of those requirements and the consequences for not adhering to them. And of course, while a lawyer may recommend a settlement to a client, the lawyer is not obligated to press the client to settle, and the client is not obligated to take the lawyer's advice to settle the case. Next paragraph. Where the client opts to pursue a settlement, the lawyer must act competently and with diligence. The client's interest may be in obtaining an acceptable resolution through a successful mediation. The lawyer's conduct in negotiating the settlement needs to be characterized with fair dealing. As we'll see, whether there may be an attorney discipline that comes from bad faith settlement conduct. There may be sanctions that could be imposed. But apart from whether or not there is some sort of penalty associated with bad behavior, settlement negotiations are much more likely to be productive, and a settlement much more likely to be enforceable where counsel act honorably and fairly and in good faith. Next slide. On the next slide, there are some discussions about the origins of good faith and fair dealing and the history of it. And I provided that there just to kind of set the context that contracts generally contain an implied covenant of good faith and fair dealing in their negotiation and in their implementation. Next slide. A lawyer in conducting a settlement should pursue it with fair dealing. But of course, you have to balance that with effective advocacy. So how do you deal with that? Well, the first instance is when do you have to start showing this good faith? Really starts at the beginning when you agree to mediate. Once there's a concept where let's go mediate, everything after that becomes, in essence, a negotiation. And communication between the parties, even prior to the mediation, becomes very critically important. Slide. For a mediation to be successful and to not break down rapidly with some element of acrimony, it's important to get the ground rules laid out straight and openly. So before one commences mediation, there should be an understanding. Who's going to make the initial demands? What offers are going to be exchanged? How are the settlement terms going to be proposed? What is the structure to this process? Are you going to, the party's going to provide a mediation statement or brief to the mediator? If so, is it going to be done openly so that each side sees what is being submitted, or privately, or some combination of both? And then critically, who is going to be at attendance at the mediation? The mediation process can be undone where these background understandings are not communicated in good faith, because it can lead to misunderstanding that then leads to mistrust and damages the negotiations, as where somebody comes to a mediation with a client, the other side does not. And then the attorney who's brought the client feels that somehow a disadvantage has been done. The attorney who didn't bring a client may feel disadvantaged, and recriminations start. Likewise, if there isn't any clear agreement about whether or not the mediator is going to be afforded any history of prior negotiations, then sometimes an Alphonse and Gaston discussion about, well, who's going to make the first offer? Who's going to make the first proposal? So it's very important to have these matters clarified at the very beginning. Next. Any change in circumstances that affects the agreement to mediate should be disclosed. An example of this would include a change in a demand or a change in an offer previously made. Sometimes things happen in court or in the context of negotiations, and prior offers or prior proposals get withdrawn. That's perfectly okay as long as they haven't been accepted. But the fact that that's no longer on the table needs to be communicated. Likewise, new evidence or information that strengthens a claim or a defense that can affect the evaluation of the case should be disclosed, unless there is some strong tactical or legal reason not to. So, for example, if for some reason the president of the company isn't coming to the mediation, but an underling is, that should be disclosed in advance. If there's been a change in the amount of insurance coverage, or an issue has not been previously disclosed about a reservation of right or disclaimer, or there is some change or previously undisclosed lien amount that can affect the settlement, that all needs to be pointed out. And generally, there's no prejudice to anybody in doing that. Next slide. Adversaries never fully trust each other. We know that. But still, that doesn't mean that you're not required to negotiate in good faith. And in fact, bad faith tactics will derail the mediation pretty quickly. We're going to try now to deal with what's good and what's bad. Next. The most problematic area is, what do you say about the facts and the law, and what do you not say about the facts and the law? What about representations of fact or omissions? This is really a tightrope for counsel, because you do have an obligation to your client to preserve client confidentiality, but you also have an obligation to be honest. Next slide. Model Rule 4.1. Now, I'm referring to the model rules because they vary. The actual rules do vary a little bit from state to state, but pretty much everybody agrees that in the course of representing a client, a lawyer may not knowingly make a false statement of material fact or law to a third person, or fail to disclose a material fact where disclosure is necessary to avoid assisting a criminal or fraudulent act by a client, unless disclosure is prohibited by Rule 1.6, which deals with matters subject to attorney-client privilege. Next matter. So the ABA guideline points out that unethical false statements may occur in at least three ways. The lawyer makes and knowingly and affirmatively a falsehood, or makes a partly true but misleading statement that is so misleading that it's the equivalent of an affirmative false statement. The lawyer incorporates a false statement made by somebody else, and in certain more limited circumstances, the lawyer remaining silent in or not responding to disclosing a material fact to a third person. Next. In 2006, the ABA Committee on Ethics, which is very influential, established that in the context of a negotiation, including a mediation, a lawyer who represents a client may not make a false statement of material fact to a third person. So while we've seen the general rule that lawyers may not make material misstatements of fact to third people, that applies in the context of negotiations. But there's a however, that statements regarding negotiating goals or willingness to compromise, as well as statements that can be characterized as puffing, or ordinarily not considered statements of fact for purposes of these rules. So let's look at some examples of this. Next slide. In matter of Gilley from the Southern District of New York in 2006, an attorney was suspended from practice in the federal court for a year originally, because the lawyer used an expert report on damages to obtain a favorable settlement, without disclosing that the plaintiff had already accepted another job. So the report went on to talk about the lost wages that the client was supposedly experiencing, when the client's lost wage claim was actually much less because the client had a job. In fact, the original suspension was for a year because the court accepted the lawyer's statement that the non-disclosure was inadvertent. However, he was suspended for an additional year after it came to light that his claim of inadvertence was not accurate. Next paragraph. An attorney was suspended in Kentucky, publicly reprimanded for failing to disclose that her client had died before entering into and consummating settlement negotiations. You know, the general rule is, by the way, when your client is dead, your authority to act is over. And you may be retained by the executors or administrators, but until that's done, you have no authority to do that. How can you go on and negotiate a case on behalf of a client who's not there and your right of agency has terminated? Next slide. So the ABA opinion points out that estimates of price or value placed on a transaction, or statements about a party's intention as to what would be an acceptable settlement of the claim, are ordinarily not statements of fact. So, for example, if the lawyer says, look, my client thinks that this object of art is worth $1,000 and they really think it's worth $10,000, that's generally not regarded as a statement of fact. But note, there is a nuance here. If the lawyer says, well, I have an art expert who's going to testify that in their opinion, the art is worth $10,000, that actually is no longer a statement of opinion. It's a statement of fact, meaning the fact being, I have an opinion that says that. Simply saying I think it's worth, or somebody might think it's worth a given number, is not in and of itself an actionable statement. Likewise, next slide. It's very common for a plaintiff to say, I'm not going to settle this case for less than $200, when in fact the client is willing to take $150. That's generally not regarded as an expression of what you would take to settle the case. Generally not accepted as a statement of fact that requires an opinion. A party in a negotiation may emphasize or de-emphasize or exaggerate the strengths and weaknesses of the client's particular factual or legal position. So a buyer of goods might say, hey, I can get these same goods elsewhere. in order to create the impression with the supplier that the supplier really isn't needed. That's generally regarded as puffing and are generally distinguishable from statements of fact. Next slide. Here are some examples of what would be a false statement of material fact. For example, a lawyer who's representing an employer in a labor negotiation tells the union lawyers, if we add that benefit that you want us to, it's going to cost us $100 per employee, when the lawyer knows that the actual cost is only $20 per employee. Likewise, if a lawyer says, I have documentary evidence that I'm going to submit at trial that is going to establish conclusively that there's a defense to this case, and no such evidence exists, that is a false statement of fact. The ABA opinion also says that it's a false statement of fact if you say it when you think that when you know that the evidence is going to be inadmissible. This is a little bit more nuanced. For those of you in New York, you may be familiar with the so-called dead man statute, under which a person who's interested in an estate is not permitted to testify as to a personal transaction with the decedent. But that's subject to waiver. So it might be possible to say, look, my client's going to testify to what the decedent had said. That's okay, because the other side can come back and say, well, we're going to object to that. Next slide. Good faith means keeping your word and honoring demands and offers. Bad faith is a moving target. So if you make an offer, don't change it on the day of or during mediation, absent a good reason. Now, that's different from giving yourself room to negotiate by saying, look, here's my offer, maybe I can do better. Or, this is what my client will pay, but maybe I can push for a little more. That's okay. But if you say, look, I'm putting $10,000 on this case, keep it there unless something comes up that gives you a valid reason for changing it. Well, as in, I made that offer before I found this witness who's now going to conclusively prove that this case has no value, assuming that that evidence is newly discovered and you didn't have it when you made the offer in the first place. Next. That's what, so, good faith requires if there's a legitimate reason to change, let your adversary know. It gives them the opportunity to reevaluate their position and potentially either postpone the mediation or decide not to mediate. Why waste time if the parties have actually moving apart? Next slide. Good faith says disclose special conditions or terms of a settlement that a party would not ordinarily expect. So, for example, if you're negotiating the termination of an employee and you're representing the defendant and you're going to say, well, look, I want a restrictive covenant that keeps the defendant from doing this, that, or the next thing, you might not always be anticipating that that's something that would be put on the table. So if that's important, you have to disclose it. Don't wait until you've cut a deal on the money and then say, oh, by the way, we want your client to do X, Y, and Z. Next slide. So good faith requires disclosing issues that pertain to insurance, whether it's what's the coverage, is there a disclaimer, do we need consent from somebody to a settlement? Bad faith is concealment. It's intentional deceit, it's misleading, it's negotiating without any intention of compromising, it's arguing a position that one knows to be false. Under the ABA guidelines, ethics rules, procedural rules, and statutes prohibit the bad faith use of the litigation process. Let's go, Sharon, to bad faith settlement tactics. So I call to your attention the State Bar of California Standing Committee on Professional Responsibility formal opinion, which gives a number of examples of what may be improper behavior that are worth pointing out. The basic fact pattern here is that the plaintiff has been injured in an automobile accident and retains an attorney to sue the driver. As a result of the accident, the plaintiff incurs $50,000 in medical expenses and the plaintiff tells the attorney that she can't work anymore. Prior to the accident, she was earning $50,000 a year. The attorney files the lawsuit, and the parties are now participating in a court-sponsored settlement conference that is going to be presided over by a volunteer attorney mediator. Next slide. So here's hypothetical number one. In the mediation brief submitted on behalf of the plaintiff, the attorney asserts that he will have no problem proving that the defendant was texting while driving immediately preceding to the accident. The attorney says that there's an eyewitness who's going to say that they saw the defendant texting, and that the eyewitness's credibility is excellent. In fact, that's not true. The attorney has been unable to locate any such witness. So the California bar says this is a misrepresentation of fact. It's intended to mislead the defendant and the lawyer. The attorney had no factual basis for making the statement. This is not an expression of opinion, but a material representation that a person would attach importance to, and this is improper conduct. Hypothetical number two. While the mediator is talking privately with the plaintiff and the attorney, he asks them about the lost wages claim. The attorney tells the mediator that the plaintiff was earning $75,000 a year, which was $25,000 more than the client was actually making. The attorney is aware that the mediator is going to tell this to the defendant, which the mediator does. Again, this is found to be improper conduct. This is not an expression of an opinion, but is stating a fact that is material to the settlement negotiations, which the other side may be relying on, which in particular in the context of a pre-discovery mediation. So this is an improper false statement. Next slide. In the same conversation, the attorney and the plaintiff discuss the plaintiff's bottom line, and the plaintiff tells the attorney that the bottom line is 175. The attorney says, nah, I need 375 to settle the case. This is allowable puffery, as I explained before. It's not an ethical violation for the attorney to overstate the bottom line as part of an effort to settle the case. Next slide. In response to the settlement demand, the defendant's lawyer says, look, we only have a $50,000 policy. In fact, the defendant has a $500,000 policy. This is an intentional misstatement. As with the first example, this is a disciplinary matter. And in addition, the attorney may be held liable for misrepresenting the scope of the available coverage. Next. Slide 5. This is an iffy one. The defendant's lawyer says the defendant intends to file for bankruptcy if the defendant doesn't get a defense verdict. In fact, 2 weeks before the mediation, defendant consulted with a bankruptcy lawyer and was advised that the defendant did not qualify for bankruptcy protection and would not receive discharge of any judgment. The defendant told his trial lawyer the results of this consultation and has also said, well, listen, because of that advice, I'm not going to file for bankruptcy. So here, a statement under these facts is false because, and is actionable because it's a statement of fact, which is my client intends to file for bankruptcy when the client has said, no, I'm not going to file for bankruptcy. And in fact, the client has said, I'm not eligible to file for bankruptcy. However, it might be different If the defendant's lawyer doesn't know whether the client intends to file for bankruptcy, doesn't know whether the client is legally eligible to obtain a discharge. So a statement that says, listen, a high verdict in this case may drive my client to bankruptcy. If you don't know about what bankruptcy means for the client in this context, that is probably not actionable. Next slide. So the case doesn't settle, but the parties agree to continue discussion. And the attorney agrees to provide additional information regarding the plaintiff's effort to find other employment in mitigation of future damages. The attorney learns that plaintiff has accepted an offer of employment and that the plaintiff's starting salary will be $75,000. Recognizing that telling the defendant about this may negatively impact the future earnings claim, the plaintiff says to the attorney, don't tell them about my new job and don't give them any information about my new job. At the settlement conference, the attorney proceeds to make a settlement demand that lists lost future earnings as a component of damages and gives a specific amount and doesn't reference the fact that the plaintiff has already gotten a new job. Next slide. So as to the underlying fact of employment, we have to assume that the plaintiff wouldn't be entitled to lost future earnings if the plaintiff found a new job and was earning at least as much as the plaintiff did before. So therefore, including lost future wages as a component of damages is an implicit misrepresentation that the plaintiff is still looking for work. Secondly, now what do you do about the fact that the attorney was specifically instructed by the client not to make the disclosure? Now that communication by the client to the attorney is of course a confidential communication that the attorney is obligated to protect. But while you're required to protect that and to follow the client's instruction, you cannot put yourself in a position where your conduct would violate ethical rules, which of course the making of a false representation would. So in this instance, when faced with the instruction, the attorney should counsel the client against misrepresentation. And if the plaintiff refuses, then the attorney needs to withdraw, as you can't make the disclosure without the client's consent, but going forward without the disclosure would constitute a misrepresentation or suppression of material evidence. And in fact, one thing to say to this recalcitrant client is to say, look, even if you succeed in not telling the other side about your new job, eventually they're going to find out about it and they can apply to undo the settlement. So you're committing a fraud and you could be liable for damages. It's a bad tactic. Some other examples in this McGrath case out of the First Department in New York in 1983, an attorney was suspended for 6 months for, among other things, failing to disclose the existence of an excess insurance policy. There was a medical malpractice case, and the attorney was representing the hospital and said that the total amount of coverage for the hospital was $200,000, which was in fact the amount of the primary policy. The attorney did not disclose that the hospital had an excess policy of $1 million. And because the hospital attorney had induced the plaintiff to believe that there was only $200,000 of available insurance, the plaintiff settled for $185,000. After the truth was discovered, the plaintiff kept the settlement, didn't seek to try to undo it, but made a disciplinary complaint against the lawyer, which resulted in the lawyer being suspended for 6 months. And in addition, got a recovery from the primary carrier and the defense attorney and the defense attorney's partner. Next slide. That came about in the Slotkin against Citizens casualty case, very same case, where the court held that a party that had been induced by fraudulent misrepresentation as to the scope of available insurance could recover damages without rescinding the settlement. Next slide. As we said before, an attorney may not employ the settlement process in bad faith, as by, for example, misrepresenting that the client is genuinely interested in pursuing a settlement when the client doesn't really intend to, or is simply trying to use settlement discussions or the pendency of them as a means of delaying the matter. Next slide. There are some things that might give us some ideas of bad faith. When somebody is unresponsive, when people try to change the topic, when they don't focus on the problem, when they claim that things are outside their control so that therefore they can't come to agreements. Next slide. Here we are. So don't ask opposing counsel to consider a possible settlement that you would never agree to, meaning, hey, how about settling for this when you know you or your client are not going to do that? Don't use the mediator to convey such a meaningless offer. And as I said, don't withhold a major settlement term until everything else has been done. Lawyers obviously may not attempt to obtain a settlement by extortionate means, such as by making extortionate or unlawful threats. Cannot threaten an adversary or a client with criminal prosecution or the divulgence of embarrassing matter in order to coerce a settlement. Now, what about a statement that says, that the facts that form the theory of the case will be disclosed if the case is litigated? Listen, you could say, if we have to go to trial in this case, there's stuff that's going to come out that could be hurt. That's not threatening to go to the DA. That's not threatening disclosure. It's simply saying a fact that in an open courtroom, things may be said that others may hear that may not be complimentary. I had a question that I'll try to answer right now. Someone asked, is it customary to ask for documents in a negotiation, for example, an insurance policy? What is the obligation to provide? It is not unusual for parties to ask to see documents before agreeing to mediation. It is not unusual to say, look, I will agree to mediate or I will condition settlement on my seeing some document. That's not uncommon. That happens all the time. And in most courts, under most rules, it is required that defense make available the extent of any insurance policy. Next slide. In the settlement context, the lawyer should not exploit an opposing party's material mistake and may have to disclose information to the extent necessary to prevent the party from relying on that mistake. Next slide. Lawyers must keep their clients informed about settlement negotiations and must promptly and fairly report settlement offers. Now, the ABA guideline can say, if the client says, look, don't tell me anything, that's okay. But generally, clients need to be kept informed of all major developments in the case, and the making of a settlement proposal is in fact a major part of the case. I can't really conceive of any situation where a lawyer should withhold an offer of settlement, or in fact, any other important information that bears on the resolution of the matter. Next slide. Lawyers have broad authority to pursue settlement if the client gives you that permission, but the lawyer must not enter into a final settlement unless all of the agreement's terms unquestionably fall within the authority that's been conveyed by the client or the client specifically consents. And here it's important for lawyers to protect themselves. There is always the potential that your client may change the client's position, buyer's remorse. Hey, I never told you that. I never authorized that. An old mentor of mine said to me once upon a time when I was a young lawyer, today's client, tomorrow's adversary. It is a good, if not always required practice to make sure your client is on board with the settlement before it's entered into, and that you have done everything you can to diligently explain the terms of the agreement. Next slide. Lawyers should provide their clients with a professional assessment of the advantages and disadvantages of a settlement so that the client can make a fully informed decision. And it's important for lawyers to give the information objectively in a way that say, look, here's my opinion if you want it, but so the client can make the decision on his or her own. And next slide. Ultimately, clients may rely on the advice of counsel in deciding to settle. Hey, what do you think? And there's nothing wrong in making that recommendation as long as you make it clear that ultimately it's the client's decision. Sometimes mediators are asked to speak to clients to talk to them about the settlement. I've had that happen, but mediators are required to say, look, I'm not there to give you legal advice. That's your lawyer's job. I'm not here to interfere in the relationship that you have with your lawyer. And I can't really tell you whether to accept or reject the settlement. It's something you should make with advice of counsel. I can answer your questions. I can tell you what I think, but I'm not your lawyer, and I'm not trying to pretend to be. It is not uncommon for lawyers to represent 2 or more clients, but you can't counsel clients about settlement if the representation of one client may be materially limited by your responsibilities to another client. In other words, don't put yourself in a position where the client's interests are conflicting, and don't put yourself in a position where potential conflicts may arise. Paragraph. These principles apply with particular force dealing with clients who are covered by insurance. The insured may be the only client, even though the insurance contract obligates the insurer to pay the attorney's fees and to indemnify the insured. The insurer may or may not be a client, depending upon applicable law, the terms of the contract, and the facts of the particular case. The inherent problem is that when a lawyer is assigned to represent an insured by an insurance carrier, you have to balance the issues. You have rights here. In most cases, the lawyer who's representing the insured doesn't represent the carrier, and the obligation of counsel is to protect the client, not the insurance company. So, for example, if there's any issue with regard to whether there is coverage, counsel for the insured does not represent the carrier on that issue. Let's go to agreements with opposing parties relating to settlement. Under ABA Guideline 4.2.2, when an attorney's fee is the subject of settlement negotiations, a lawyer may not subordinate the client's interest in a fee, in a favorable settlement to the lawyer's interest in a fee. Very simply, your fee should not influence your conduct in negotiating a settlement on behalf of your client. It's not uncommon for there to be provisions either in a contract or in a statute or that permit the prevailing party to recover attorney's fees. Not uncommon for defendants to say, I want to settle everything. How about I pay you this for your client and this for your fee? It's important not to subordinate the client's interest in the client's recovery because you have an interest in whatever the outcome of the fee negotiation is going to be. In fact, I've had circumstances where attorneys have said, I don't really want to discuss my fee until I see what my client's going to get, and not do it as an all-in in order to avoid the ethical problem that arises. Next slide. Lawyers may not agree to refrain from reporting opposing counsel's misconduct as a condition of settlement. Lawyers have an obligation under the ethics rules to report misconduct by other lawyers. It is improper as part of a settlement agreement to say, I will not report your misconduct because we are entering into the settlement negotiation. If it's not made a condition of settlement, lawyers then have to decide whether or not the offense is reportable, meaning that even if the case has been settled, if a reportable offense has been observed by the lawyer, it must be reported. Next slide. It's a conundrum. In most jurisdictions, lawyers have an ethical obligation to report another lawyer's serious disciplinary misconduct to the appropriate authorities. These are mandatory and cannot be vitiated by a private agreement, including a settlement agreement. So the only way that it would be permissible to say, I'm not going to report you, is if, in fact, you don't have an obligation to report you. That's a little different from agreeing to a general confidentiality clause, which says, okay, the terms of the settlement are going to be confidential, but that can't obligate a lawyer to refrain from reporting the other lawyer's misbehavior. Next slide. In representing clients, lawyers may not use means that have no substantial purpose other than embarrassment, delay, or burdening the third person, nor use methods of gathering evidence that violate the legal rights of a person, meaning that lawyers can't do things just simply to embarrass people or intimidate them or cause them burden. Now, there's some things that may have an effect of creating embarrassment, delay, or burden, but if there is a legitimate purpose to be served, for example, lots of people might find it burdensome to have to complete interrogatories. But if the interrogatories are legitimate and lawful and reasonable, and you're entitled under the discovery rules to pursue them, it's not a violation to pursue those as long as you have a legitimate purpose. Next slide. We've all had or maybe seen the problem of the accidentally sent transmission. The model rules of professional conduct kind of reflect a big debate on what is the receiving lawyer's obligation. And the way Rule 4.4b settled on this is to say that a lawyer who receives a document or electronically stored information relating to the representation of the lawyer's client, and knows or reasonably should know that the document or electronically stored information was inadvertently sent, shall promptly notify the sender. So it simply says, look, you got to tell the other side that you got this. It doesn't grapple with, all right, now that I've told them, what am I supposed to do? Am I supposed to send it back? Am I supposed to disregard it? May I use it affirmatively? California's version of 4.4 says that if you get it and you know that the writing is privileged or subject to work product, then the lawyer must refrain from looking at it to any extent greater than is needed to determine that it's privileged or subject to work product, and then must promptly notify the sender. It is not uncommon as part of settlement negotiations, particularly where there has been a lot of discovery of material that is confidential or regarded as such or subject to a confidentiality agreement that says, all right, now that the case is settled, we're going to return documents or commit to destroy them. Unless there is some specific law or provision that renders it improper or unlawful, it is generally permissible to agree, okay, I've gotten these materials, I am going to return all of them to you, or I am going to destroy them. And then counsel must use care to ensure that anybody you gave access to the documents to, in fact, surrenders or destroys them. And therefore, a process for the mutually assured destruction of these documents is important. Lawyers may negotiate and be bound by an agreement to keep the settlement terms and other information relating to the litigation confidential. That's perfectly okay, generally speaking. If one of the advantages of mediation and one of the advantages of out-of-court settlements is to avoid the publicity and the publication of items that otherwise would be out in the public domain. If a settlement agreement is filed in court, the settlement agreement is normally open to public inspection, and people can see what happened. If it's spread on the record in court, it may be publicly available. So it's perfectly okay and consistent with the objectives of obtaining a settlement or having a successful mediation to agree that the terms of the settlement will be kept confidential. Back one, Sharon. Lawyers are also ethically bound to abide by the ADR provider's rules. I work with NAM. It's been a great organization, and NAM has its own rules about how a mediation is to be conducted. Parties are often free to vary those rules, but if you enter into a mediation and it says these are the rules, then you're obligated to follow those rules. And of course, counsel should always read them. So if there's a pre-suit mediation requirement and it says we're going to do this under NAM, make sure before the mediation starts that you read the NAM rules. If you're going to agree to use a particular mediation provider, in deciding what provider to use, take a look at those rules. Because absent a modification that you willingly make and that is accepted by the provider, you're obligated to follow those rules, and the mediator is going to enforce them. Lastly, in the context of drafting an agreement, lawyers should endeavor in good faith to state the understandings of the parties accurately and completely, and to identify changes from draft to draft. It's unprofessional, if not unethical, to knowingly exploit a drafting error or similar error regarding the context of the settlement.
Judge, you have several questions. I don't know if you're done yet or just want to.
I see one, which says that the attorney suggests that they don't think an attorney should advise the insured regarding a coverage issue since the attorney is being paid by the carrier. I believe that's right. That you can't. Separate coverage counsel needs to address that issue. Sharon, do you have another question?
No, I don't. I thought there was another one. I saw the one at the end, point of information when representing an insured. Did you just read that one?
Yes.
Oh, okay. Nope, there's one more after that, but I think that's it.
Let me see. So the question is, if you inadvertently see a document and it has something critical to helping your case, are you permitted to use it, for example, in a motion? And that's an interesting question. And it's subject to the great legal answer, which is it depends. And what does it depend on? It depends on the jurisdiction that you're in. You all may be familiar with the infamous story that happened not so long ago in the case of Mr. Jones, the podcast person who was denying the Sandy Hook events, and he was being sued by the families of the Sandy Hook victims. And in the course of the matter, counsel for Mr. Jones turned over to the plaintiff's side many emails and documents that had previously been denied to have existed, and they were used with great effect on cross-examination. That matter happened in Texas, and there was no provision in the Texas rules that barred it. So one would in California, there would be an obligation, for example, to notify. In a rule in a state that just has the ABA model rules, there would be an obligation to notify, not necessarily return. The idea is if you notify, then your adversary could take action and potentially seek to have it suppressed. But if you notify them and they don't seek to have it suppressed, presumably it's fair game. If you notify them and they do take action, then you'd be obligated to follow whatever decision the judge in question makes. So that's a very, very, very jurisdiction-specific point. I think, Sharon, that's the questions.
That's it. I don't see anything further. So unless you have anything else to add, Judge, I will want to thank everyone for joining us for Judge Scheinkman's presentation today. And we look forward to seeing you at future presentations. Thank you.
Thank you very much. It's been fun being with all of you. Thank you.